Welcome everyone who is joining. We're going to wait a few moments before we get started here to allow more people to join the webinar. Okay, I think the numbers are stabilizing now, so I'll go ahead and get us started. Welcome everyone to today's webinar, which is about the new VCU labels, which were released in the August 2023 VCS program updates. My name is Nicole Shermer. I am the manager for VCS program development at Vera. And I'll be joined today by a number of my colleagues who will each introduce themselves as they begin to speak. A couple of housekeeping items before we get started. This webinar is being recorded, and the recording will be available online after the webinar on the Vera website. If you pre-registered for this webinar, you should also receive the recording in your email after the webinar. Right. So the objective of today's webinar is pretty straightforward. We're going to give an overview of the new labels that were released in August. We're also going to be able to answer questions from participants about the new labels. A couple of notes about questions. You may ask questions in the Q&A box, which should be at the top or bottom of your Zoom screen throughout the webinar, and questions will be answered at the end. We have enabled an upvoting function in the Q&A for this webinar, which means you'll be able to see what questions others have submitted and upvote the ones which you think are most important or ones that you're most interested in having answered. For that reason, please review questions that have already been submitted before writing your own to avoid duplication. Of course, because this is public, we ask that you be relevant and respectful in your questions. You do have the option of ticking anonymous if you would like to submit a question that way. If you do, we may not be able to follow up with you after the webinar, which is always an option. And if we are not able to answer your questions during the webinar, you can also follow up with us directly via email, which will be provided at the end of the webinar on a slide. But just to say it now, our email for our team is programupdates@vera.org. If you want to ask about program updates, info@vera.org for more general questions or questions specific related to projects, or registry@vera.org for questions related to the registry or general questions about labels. The agenda for today's webinar, which should be about 60 minutes long. Number one is an introduction to VCU labels, a bit more general about how VCU labels work on the registry. Second, an introduction and overview of the new labels that were introduced in the program updates, including mitigation outcome type labels, so removals or reductions, Article 6 labels, and CORSIA labels. Finally, we'll save at least 15 minutes at the end for a Q&A. So to say a few words introducing these new VCU labels, the ones that we're going to talk about today came about from a few different sources, of course, hearing lots of input from stakeholders, including these consultations that were relevant to the labels, especially the June 2022 consultation on new Vera unit labels, which specifically was about these removals reductions labels as well as Article 6 labels. In the August program updates, a number of resources were released which correspond to these new labels. These can be found on the VCU labels page, the link to which is at the bottom of the screen. And again, these slides will be made available in PowerPoint version after the webinar, so you can come back and click on that link if you wish to do so afterwards. A couple of words about what are VCU labels, just in general. A VCU label is essentially a marker that indicates an additional characteristic of a VCU, such as that it meets the requirements that are set outside the VCS or are approved for use in another market. A certification label, for example, indicates that labels relate to other standards or programs developed by other nonprofit or governmental organizations that are not the VCS. So for example, CCB, which is a VEER program, can have a label applied to VCUs, which is the most common use for these certification labels. And any other certification type organizations may also apply to have labels as VCU labels. Market labels identify that VCUs are eligible for use in other specific domestic, sectoral, or investor-specific markets. And these are the type of labels that we're talking about today: the removals, reductions, Article 6, and CORSIA labels. For more information, there is these specific sections of the VCS program documents on the screen here, which are specifically about VCU labels and the difference between them. Now I'm going to pass it along to my colleague, Kelly, who will introduce herself and talk a little bit in general about how VCU's labels are applied in the registry.
Hello, thanks, Nicole. My name is Kelly Peak, and I am one of VEERA's registry managers. And I'm going to go through a couple slides here, just kind of talking about, as a reminder, kind of on specific label functionality inside the registry system. So, like existing labels in the registry, if you've had experience kind of applying the current CORSIA labels and that sort of thing, account holders may add these new market labels to their issuance requests by clicking on the additional certifications link on the project's verification summary page. And this is the page where your vintage and verification records are stored on a project. For reference, here's kind of a quick screenshot that shows kind of the highlighted link about where you're going to click to find the additional certifications page. Next slide. So once you're on this additional certifications page, you're going to select the desired kind of market labels one at a time from the drop-down menu in this kind of first other certifications section at the top of the page. You're going to add the verification start and end date over to the right side. You're going to repeat this as much as needed. So if you want to add, several different Article 6s or reductions, removals kind of all at the same time, you'll have to repeat these steps to kind of add each one onto this page. You're still going to have access to, if it applies to your project, the CCB and SD Vista. Those are kind of separate sections to activate down below. And then once you're kind of finished adding whichever labels you want to this page, activating CCB or SD Vista as needed, you're going to click Save at the bottom of the page and then proceed with your issuance request, kind of as normal as usual. One important note for this page is that right now, with the way the registry functions, all vintage records are kind of linked together with your verification record. So basically, once you fill out this page for one vintage in a verification period, it's going to automatically appear automatically in all the other vintages related to that verification period. So you only need to perform the step once and go into the screen one time. Once you submit all of your issuance requests, the registry team is going to review them, your pending issuance requests as normal with these labels added. We're going to ensure that if there's any kind of corresponding eligibility requirements you need to meet, we're going to check for those. We will obviously reach out to you and correspond if needed, if we need additional information to make sure the labels are approved. And then at that point, we're going to generate the applicable invoices. It's important to note there's no additional fees associated with these market labels. So basically, once you pay your VCS issuance levies, we're going to issue your credits and they'll have these labels attached to the serial number. Next slide. So we recognize that this is kind of an increasingly complex nature having to do with labeling. So therefore, we're going to be working on the registry's functionality having to do with this. We recognize there needs to be a much more nuanced application of labels, particularly at the issuance request level. As I kind of noted, the way that labels currently function, it's like, once you activate for a vintage, it's on all vintages in the verification period. And we recognize that going forward, that's going to cause some problems. So we are working with our developers to kind of come up with a better solution, so you'll actually be able to select different labels for each issuance request kind of as you submit them. We're aiming to have this new functionality kind of available towards the end of the year. There will obviously be much more information coming out about that in a release note kind of once it's available. But I just wanted to mention that just kind of to head off any questions that yes, we are going to make this better in the future. But until this new functionality is updated, as I've noted here, account holders kind of continue to submit label requests, as we've described for any new issuance requests where the same label is going to be used across the vintage. You'll have no problem doing it the way that I've described. But if you have a much more detailed request that you need to make, a much more nuanced application you need to do, the best thing to do is going to be to reach out to our team and we're going to help you. So if you've got a more detailed labeling request, I put a few examples on the slide. Say you want to apply a market label, but you want to do it retroactively to credits you've already issued, or you want to apply an Article 6 label to only a subset of the vintage period or some of the vintage periods in a verification, but not all of them, or you want to apply an emissions reduction label or a carbon removal label, kind of like a mixed situation on a vintage, that sort of thing. We recognize there are limitations with the current system, so the best thing is going to do is reach out to our team. And we will help you through the process. We will make it as smooth, as painless as we can. So, well, one caveat here is please reach out to us as soon as possible if you're in kind of one of these more detailed situations where you're going to need our help. We just want to make sure you're not kind of coming up on an urgent deadline to deliver credits where they need to be labeled. And so, the more time you give us to help you, the better we can get through that and work with our developers if we need to, and that sort of thing. So that's just kind of going through the simple, kind of straightforward application versus the more detail-oriented applications. If y'all have any questions, let me know in the chat. Thanks.
Thank you, Kelly. And now we're going to pass it along to our colleague Christian to talk about these mitigation outcome type labels.
Thank you. So our engagement on labels last year confirmed that there was a high interest in the market to differentiate the VCUs that represent emission reductions from those that represent the carbon dioxide removals. And therefore, we have developed the voluntary market labels for VCUs to represent the two mitigation outcome types. You can find more relevant background information and guidance on requesting these labels in a document we have published on our website, which is called the Mitigation Outcome Label Guidance. Verified removals and reductions are eligible for greenhouse gas emission reduction or carbon dioxide removal label at the VCU issuance. However, the label is optional for all the VCUs projects, and the proponent may decide whether to use it or not. Already issued VCUs may also be eligible for labels, but only for those projects that use methodologies with only greenhouse gas emission reductions or only carbon dioxide removals. Also, at the moment, only projects using methodologies with 100% reductions or 100% removals are eligible for the labels. Methodologies with both mitigation outcome types will be revised by Verra to make them eligible for the labels. Finally, what Kelly already mentioned is also that the Verra registry functionality to enable the labeling of VCUs from projects with both removals and reductions is also under development at the moment. Next slide. In the August updates, we included definitions for reductions and removals in the VCS program definitions, as well as updates to the methodology requirements with rules to determine reductions and removals within methodologies that contain both mitigation outcome types. The methodology requirements include rules for the breakdown of removals and reductions, and specifically for the allocation of project emissions and leakage emissions to each of the mitigation outcomes. If the emissions can be clearly attributed to the reductions or removals, then they are discounted from the corresponding mitigation type. If the emissions are associated with both types, then they are allocated proportionally to each of the mitigation outcome types. So for example, if there's a CCS project, carbon capture and storage project, that has both direct air capture and post-combustion capture from a flue gas and from an industrial facility, for instance, in such a case, the emissions that are associated only with the direct air capture would be allocated to the removals, and the other way around for the emission reductions for the flue gas. If there's emissions in this case that, for instance, from energy consumption for shared infrastructure, for instance, for transport, then they will be allocated proportionally in this case. The leakage emissions and non-permanent in this case. Next slide. So the appendix of this mitigation outcome label guidance I mentioned before provides the mitigation outcome type and eligibility of each methodology for the label. The mitigation outcome type and compatibility with the label is also included on the web page of each methodology. You can already see this information on each website of each methodology, and you will see basically the differentiation between reductions, removals, or if it has both, and then also whether the methodology version is already eligible for the label or not. Labels will only be available for projects using the methodologies that are either 100% reductions, 100% removals, or have already this explicit breakdown within the methodology as per the methodology requirements. Reporting the breakdown between the two mitigation types is mandatory as of 1st of March 2024 for methodologies that contain the breakdown, but the labels will only be applied where requested. So as said, that this is optional. Vera will revise all the methodologies that are not yet eligible for the label and issue a new methodology version over the next few months. For clarification, the mitigation outcomes of all CDM methodologies are also indicated in the guidance, and all of them are emission reductions except for afforestation and reforestations for both wetlands and non-wetlands.
Thank you, Christian. And now we'll pass it along to our colleague, Andrew Howard.
Great, thanks, Nicole. Andrew Howard, Senior Director for Climate Policy and Strategy at Vera. So I'm going to talk through some of the background to Article 6 labels, first of all, and then my colleague Ashley is going to take over and tell you what it is you can do and how you get the actual labels. So first of all, here you see the link to the Article 6 label guidance. We have attempted to put together as succinct as possible version of the background for these labels, as well as how you actually get them. So they're contained in this document, so please do have a look if you haven't seen it already. It is a complex field, so we have tried to put things forward in a straightforward way as possible. Okay, next slide. So kicking off with some of the background, I think most of you will be aware that Article 6 of the Paris Agreement has really come about in its initial form as a way of countries being able to cooperate with each other. So each country under the Paris Agreement has plans, has targets for how much it should be reducing its greenhouse gas emissions by. They contain these within their nationally determined contributions, their NDCs. And what Article 6 is for is to be able to have countries which can transfer mitigation outcomes, as they call them in very generic terms. They can transfer mitigation outcomes between the countries' NDCs. And that's really where you see the origins of this. And you can imagine different ways of doing that. I think in the initial constellation of ideas around here, there were thoughts around joined up compliance markets, so you could actually have two countries that might have an emissions trading system together, for example. I think we're not quite at that stage yet in the way the policy development has gone, but we are at the stage where certainly the mitigation projects can be leading to these mitigation outcomes represented by our VCUs, for example, and these can be transferred back and forth between countries. And of course, it's a trade between the financing on the one hand and in return for credits on the other. And any international transfer of these mitigation outcomes needs to be counted against the buyer country's NDC. So it contributes to the buyer country's NDC being achieved rather than the NDC of the host country. And this is all required in order to avoid double counting, and that's where the famous corresponding adjustments come in. So I'll say a little bit more about that on the next slide. This original scope of being purely country to country has been nuanced or expanded a little further in the actual rules that we had developed for the Article 6. This was in the Glasgow COP in 2021. The original scope is the first one, the first bullet here, the use towards NDCs, very much country to country transfers, and that is mandatory. So if countries are transferring, and if a acquiring country is taking benefit of the mitigation outcomes, then they must account for this. Countries must account for this under the UNFCCC, under the Paris Agreement. The other nuance which was included, though, was what has been called international mitigation purposes. And this is really referring to international agreements of a UN kind of treaty nature, but other than the Paris Agreement. So the only example of this we have at the moment is CORSIA, the Carbon Offsetting and Reduction Scheme for International Aviation, which is run by the aviation arm, civil aviation arm of the UN. And any VCUs which are counted towards these CORSIA purposes also must undergo mandatory accounting on the part of the host country. So a host country is essentially transferring the mitigation outcome into the CORSIA program, and the host country has to account for this as well. The third one was also added in Glasgow, and this is called other purposes. It's a very generic term, but it is commonly understood to include the voluntary market. So this is where a country may sanction the fact that the credit or the mitigation outcome is being used in a voluntary market setting, so towards a voluntary goal. And this has been specified as being optional. So it's not the case that a host country must include this within its Article 6 accounting, but it may do, and buyers may see a benefit of that as well. So if we go to the next slide. The way that this happens in general terms is that in order for these international transfers to be included in Article 6 accounting of the host country, then first of all, the host country has to give its authorization. And the way that it gives that authorization is through a letter of authorization. And these are issued by an authority of the host country. It must be the authority which has been designated and has the authority within that country to issue those LOAs. The LOAs really amount to a commitment on the part of the host country to undertake the corresponding adjustment for the transfers which are being made. And this, in very simple terms, a corresponding adjustment is, for the host country, is an addition of an amount which is equivalent to how much was transferred. And that amount is added to its national emissions total. So what happens is the project reduces the emissions, and the corresponding adjustment comes along and it adds back to the level of national emissions in the country. So it restores the accounted level of national emissions. So the effect of that is that the reduction in emissions which occurred through the project no longer counts towards the country's meeting of its NDC. And that is because it's being used in these other purposes in order to avoid the double counting towards NDCs and towards international mitigation purposes, aka CORSIA, but also if the country is voluntarily doing this, then the use towards other purposes or the voluntary carbon market. Next slide. So this slide goes into something which is a bit more complex, and there may be some questions at the end, so I won't go through this in detail at the moment. But essentially, the authorization is the permission, if you like, for that the host country gives for the credits to be used in certain ways. But that doesn't actually immediately trigger a corresponding adjustment or the need to do a corresponding adjustment. Host countries are required under the Article 6 rules to do these corresponding adjustments when something called a first transfer occurs. And the first transfer through the negotiations has actually been broadened out into a number of different interpretations, and the host country may determine what it wishes to constitute as being the first transfer condition. So you can see on this table across the horizontal column 4 different potential triggers or first transfer conditions, which the host country may choose between. Authorization, issuance, the first international transfer, and then the use. And use is what Vera refers to as retirement. So there are different options which can be applied to the different authorized uses. In very broad terms, NDC use is very specific. It has the first transfer condition of the first international transfer. This is really just the first time that a credit gets transferred from one country to another, from one registry to another. And this follows the general logic of the Article 6 rules. When in Glasgow, the additional nuances for international mitigation purposes and other purposes, CORSIA and voluntary carbon market, were added. The complication there was that very often this is implemented actually not with a transfer from one registry to another, but simply by retiring a unit within a single registry. And therefore, when they did these Article 6 rules, they looked for different first transfer conditions, which would then trigger the obligation to do the corresponding adjustment. And so here we see for the first time authorization, issuance, and retirement coming in as first transfer conditions. It does complicate the picture. The key is that the host country is able to indicate, ideally through its LOA, which of these conditions is used. One thing that we are quite supportive of is that a country would be able to specify multiple uses, so it would actually just be able to say these credits are authorized without necessarily specifying whether it should be for NDC use or CORSIA, etc. And in such a case where this is the multiple use is included in the LOA, then what we would look for there is the first international transfer as being the first transfer condition. And that's simply because the NDC use is included there, and that's more restrictive than the others. So next slide, please. Once the LOAs are in place and the actual projects are occurring and the transfers are occurring, then there should be over time the actual corresponding adjustments which are implemented by the country. Now, we do plan to keep track of whether the corresponding adjustments are actually being done by the host country. The status of that will be kept on the VCS Public Reports tab on the Vera registry directly. And that's where we'll present the results of our monitoring. Now, the monitoring will be of the biennial transparency reports and perhaps other sources of information. These reports, which were noted on the last slide, they are indeed every 2 years. We don't yet fully know the format of those BTRs, so it's a little difficult to say exactly how the monitoring will occur, but we will be monitoring in some fashion in order to be able to keep track of this and present the results to you. There are a couple of instances where it would be necessary to withdraw the label and as part of the monitoring that is occurring. One is where if evidence of a corresponding adjustment is not observed within 2 years of its required application, then we would need to withdraw the label. Now, just to be clear, if a transaction occurs today, then that might not be picked up in the biennial transparency report until 2 years down the track. And what we're talking about is 2 years after that. So it could be around 4 years from the time of the actual transaction. So there is quite a large lag of time, which is allowed there for countries to be able to make these corresponding adjustments and report them. Under some accounting measures, it might even take longer than that. And what's emerging, and this is something which has come through the Integrity Council for the voluntary carbon market as well with its assessment framework, this is emerging as a kind of standard for what sort of time frame should be given. So 2 years after it should be given. We are aware that if the VCU has already been retired, then that could have particular impact on market value. So here we will intend, or what we'll do is to give advance notice of an impending withdrawal in order to give account holders or project proponents sufficient time to be able to contact the country and see if the the corresponding adjustment can actually be made. The second instance is of where a label could be withdrawn is when the host party has actually completed its accounting for the relevant NDC period, and therefore it's no longer able to apply a corresponding adjustment. And this would occur in a situation where a country gets to the end of the NDC period, in fact, several years after the NDC period, and then it goes through all of its counting to kind of close its books on the NDC period. And still within all of this, the first transfer condition has not been met, so there is no obligation on the country to do the corresponding adjustment. As that rolls into the next NDC period, the opportunity to do the corresponding adjustment for those credits in those vintage years will have gone, and therefore there's no point in having the label on the credit anymore. So that's the monitoring of adjustments and instances where we may need to withdraw the label. So with that, I'll hand across to Ashley, who's going to take us through the practical implications.
Hi, everyone. My name is Ashley Sorar. I'm a senior program officer with the VCS program developments team. I supported some of the updates related to Article 6 and CORSIA from the process side. So at the beginning of this presentation, Kelly gave you a step-by-step guide on how to apply for a label on the VERA registry. I just wanted to ground some of these concepts on Article 6 and walk you through a few additional steps on process. So we tried to make the process as straightforward as possible, as some of the concepts are a bit complex. So to reiterate, project proponents can apply to receive up to 3 labels on the VERA registry to identify VCUs that have been authorized by host countries for use under Article 6 of the Paris Agreement. The 3 labels include NDC use, which means it's authorized for use towards an acquiring country's nationally determined contribution. Second, international mitigation purposes, which means it's authorized for use for international mitigation purposes other than a country's NDC. And finally, the last label, other purposes, which means the VCU is authorized for all their uses other than NDC and international mitigation purposes. And this includes use in the voluntary carbon market. Again, these authorized uses align with what my colleague Andrew was just discussing. I wanted to note that Article 6 authorization can only be requested for VCUs representing emissions reductions and removals from January 1st, 2021 onwards. The main piece of evidence required to obtain an Article 6 label is to upload a letter of authorization, which should be signed by the host country and again uploaded to the VERA registry. The letter of authorization may be uploaded at any time after a project is listed on the registry. VERA will then review the uploaded letters for all required information before making them public. Next slide, please. So VERA will check the following 5 eligibility criteria before issuing Article 6 labels. First, VCUs should, again, represent GHG emissions reductions or removals made from January 1st, 2021 onwards. 2, the letter of authorization should contain all specified information as outlined by what I will outline in the next slide. 3rd, the letter of authorization should be issued and signed by the authority designated by the host party to provide authorization under Article 6 of the Paris Agreement. 4th, VCUs should meet all criteria as specified in the letter of authorization. And 5th, the host party should be able to still apply the corresponding adjustment in the calendar year in which the mitigation outcome occurred, which means the host country has not yet completed their reporting for the NDC implementation period. Next slide, please. So as I mentioned, the letter of authorization, the written authorization by the host country is the main document that needs to be uploaded. The following information requirements need to be included in the letter of authorization. And at a high level, they include information on the authority representative of the host country and the relevant contact information. Second, information on the project, including project ID if it's available and applicable, and the project location. And lastly, the following Article 6 specific information should be included so that we can complete the relevant checks in the future. First, it's a specification of the authorized uses. So it can either be specified as all uses, which include all three of the labels, or it can be specified as one of the following, one or more of the following, so NDC use, international mitigation purposes, or other purposes. Second, the first transfer condition should be specified. I believe Andrew will go into more detail in the question period, but it should either be for all uses or NDC use. The first international transfer should be specified, or for international mitigation purposes and other purposes, it should be authorization, issuance, or use that would be specified. Again, this is kind of outlined in instructions in the template itself, so it'd be relatively straightforward to choose one of these boxes. And then lastly, the corresponding adjustment commitment should be specified in the template as well. Next slide, please. So all of this can be a bit complex to navigate. So we've essentially created a template for the letter of authorization to kind of streamline the process a little bit more. This template is available on the VCS labels website. And the template is intended to assist project proponents in approaching the host country when requesting Article 6 authorization. Using the template is optional, as the host country may provide letter of authorization in any format of their choice, provided all the required information that I just discussed is included. Again, project proponents may upload the letter of authorization to the registry anytime after the project is listed, and all information and requirements, including instructions on how to complete the template, is included in the template itself. So project proponents are encouraged to review the Article 6 guidance document in detail and use it in tandem when filling out the template. I will now hand it back to Andrew Howard, the Senior Director of Climate Policy, to give a few more details on Article 6 retirements.
Yeah, thanks, Ashley. Yeah, we wanted to give you a bit of information on the retirement because there are some differences. In terms of the actual process, it's just like any other retirement that you would do with VCUs. So it's the same process with the registries. There is a couple of restrictions, though, in terms of which labels you need to have in order to retire against certain purposes, and they're set out in this in the table here. So in the first example, and this is fairly straightforward, in order to be able to retire against CORSIA, then you need to have the authorization of international mitigation purposes. So that's the CORSIA one. And just to be clear, a VCU needs to have two labels for this. If you're retiring against CORSIA, you need to have both the CORSIA label and also, which is currently a requirement in our system. And in addition to that, if you're dealing with VCUs with vintages of 2021 onwards, you would also need to have this Article 6 authorized international mitigation purposes label. So without those two labels, if we're talking about post-2020 vintages, then you won't be able to conduct the retirement. That will not make any changes to what you're currently able to do with CORSIA retirements in the system. What we are currently eligible for under CORSIA is for vintages up until 2020, and for that there is no requirement to have the Article 6 authorized label, and that's simply because those vintages are occurring prior to the time of the Paris Agreement. In the second row here on the table, this is dealing with the Article 6 label for NDC use, and this is required for any compliance-related retirement reasons which involve an international transfer. And again, we're only talking about vintages from 2021 onwards, but let me just illustrate that with a couple of examples. So the government of Singapore is allowing VCUs from next year to be surrendered against its carbon tax. And in order to do this, the one way of implementing that is to be able to retire them on the Vera registry. But because that retirement reason is associated with a compliance market in Singapore, and there's also an international transfer of credits embodied within that, then you are in a situation where you would need to have the Article 6 authorized NDC use label. I'll give you another example, and that's the South African case at the moment. So South Africa also allows VCUs to be used against its carbon tax. However, it only allows VCUs which are generated inside of South Africa. So there's no international transfer there. And in that case, you do not need to have the Article 6 authorized NDC use label. So there's a number of different issues here which are happening. But I think the key thing to remember is that any compliance-related retirement reason, which does actually involve this international transfer, that will need to have the NDC use label. And next slide. This slide is about the transparency of retirements. We do intend that all retirements which are made with Article 6 labels would be made public, and this would refer to the quantity, of course, but also the retirement beneficiary. And in order to do that, the information will need to be, in the interim period, will need to be specified to be made public on the VERA registry. So we do intend to automate this function so that, in fact, when you come to the retirement screen, you would only have the option of making it public, but in the meantime, we will require that each retirement transaction actually ticks 2 checkboxes, which are highlighted here in yellow on the retirement screen. But the intention going forward is that all of this will be transparent and publicly available. So I think with that, that covers what we wanted to say on the Article 6 labels. So I'd hand back now to Ashley to talk about CORSIA labels.
Thanks, Andrew. So now I'll give a brief update on CORSIA labels. So the International Civil Aviation Organization, in short, ICAO, sets criteria for CORSIA eligible emissions units. So the VCS program is already approved for the 2021-2023 pilot phase of CORSIA compliance. This means that VCUs that started their first crediting period on January 1st, 2016 onwards, and represent emissions reductions and removals that occurred through the end of 2020 are fully approved for use under CORSIA for the 2021 to 2023 compliance period. So please see the VCS labels on the ICAO eligible emissions units document for more information on approved methodologies and criteria for this past assessment of CORSIA program eligibility. So to align with the difference in compliance period distinctions, effective immediately, we've updated all CORSIA labels to reflect the pilot phase or 2021 compliance period. ICAO recently reassessed which programs meet requirements for the next round of CORSIA compliance. Through this assessment, the VCS program received conditional approval for the next phase of CORSIA compliance, which is called the first phase and represents the 2024 to 2026 CORSIA compliance period. The recent VCS updates fully align the VCS program with all eligibility criteria required for the first phase label. Last month, VERA also submitted a formal communication to ICAO to request full approval for the first phase label. So VERA expects to be fully approved for the first phase label by March 2024 at the latest, and ideally sooner. The CORSIA first phase labels will be available immediately after receiving this approval from ICAO. So VERA will also publish a CORSIA guidance document, similar to the Article 6 guidance document that's been posted on the VCU labels website. And this will outline the eligibility criteria for project proponents to apply and obtain CORSIA first phase label. And it'll also give a bit more detail on the pilot phase as well. So all these updates are forthcoming on both CORSIA labels. So please stay tuned for additional updates. I'll now pass it on to Justin to lead our Q&A.
Hi, Justin. It seems like you might be muted.
Can you hear me now?
Yes, now we can hear you.
Okay, sorry. So as a reminder, please look at the Q&A and upvote any questions that you want answered, because we will go based on the number of upvotes. We'll go for 15 minutes to the top of the hour. So the first question is a little bit complex. Andrew, I think this is going to be you. So if a particular country has its own GHG emission reduction certificate, which resembles a VCU, but may not be acknowledged by Verra as a VCU, what should the project proponent do if they're developing a Verra project in that jurisdiction and wanting to get a authorization? I think the short answer is you can only get an Article 6 label if you get an authorization from the country. So you should approach the country and request that authorization for your VCS project. But Andrew, I'm not sure if you want to add any color to that.
Sure, I'll try. It's not entirely clear to me what the question is really asking. I think in the if the country is saying that in order to do a project you must go through their own crediting program, then Verra is not in much of a position to do anything. I mean, I think what would be worthwhile perhaps doing is to approach the government and see if there's an opportunity to be able to run the project through Verra. There are countries which are accepting this, and I do expect their number to grow in the future. So I think it would be worthwhile trying to see if the country would accept to run the project through our MRV system and our project cycle, and yet still to have the authorization letter.
Great, thanks, Andrew. The next question relates to CORSIA. Once Verra is fully approved for phase 1, once Verra is fully approved, will projects meeting phase 1 vintage and other requirements be eligible for the CORSIA phase 1 label, or will they have to wait until after the host country provides a letter of authorization? So the two labels will operate in parallel. You can request the phase 1 label once that's all fully done, as you say. And then separately, you can request the Article 6 label as soon as you have the letter of authorization. So we don't have a order of operations requirement between the two, but you will need both to retire against that reason. But Andrew or Ashley, do you want to add anything to that, or does that capture it?
I think it captures it already.
Okay. Andrew, I think the next one is for you too, so I'm glad you're off mute. Considering the recent development made by host countries in the past few months, what would happen if a country initially agrees to make a corresponding adjustment for some credits, but then changes its mind because it's not on track to meet its own NDC?
Yeah, I think this is a common concern, and it's a new element of government risk, I think, which is facing projects. It's difficult to know how to handle it, but I think what it comes down to is it's a contract between by the project proponents and the governments or the project proponents which are working in country. So it's very difficult for us to be able to say what should happen in that case. I think we would take it on a fairly factual basis, but I think that it is very important that projects should be putting in place as strong a contractual basis as possible with the partners in country in order to try and avoid this kind of scenario. What would happen for us if the corresponding adjustment really was not done in the end, and as I said in the presentation, there are many years in play for this, but if, say, 4 years down the track, as I was in my example from earlier, the corresponding adjustment has not been done, we would be required to withdraw the label from that. That doesn't make the transaction fall over. The transaction is still as valid as it was before, but the extra value which is contributed by the LOA would not be present in that. And there are so many different variations of what the implications of that could be that I don't want to opine on that here. But that's what we would need to do But it is, as I said earlier, and I try to stress it again, it is many years down the track, and we would hope that the whole situation with corresponding adjustments will have settled by that point, and countries would indeed adhere to what they committed themselves to.
Great, thanks, Andrew. The next question is, have any LOAs been reviewed by Vera at this point? Where can we find this info on the website? So this is all very new. We just enabled the labels at the end of August. I don't believe we've received any LOAs yet for review. Once a letter of authorization has been reviewed and approved, that will be available on the project listing on the registry. And then the labels will show up as labels on the registry. So if a VCU is issued with a label, then that's publicly visible, and you can access that through the registry by filtering by the label type that you're interested in. There's a question, this is probably for you again, Andrew, for Article 6 label. What if the country is not yet able to publish its NDC regularly? Can the VCU still be labeled Article 6? If yes, on which conditions? Basically, you need a valid letter of authorization, is the conditions. But Andrew, do you want to say a few more words on that?
Yeah, I think countries are publishing their NDCs. There is an expectation that countries will update those NDCs every 5 years, but most countries have NDCs in place already, and most of them go through till 2030. So I think the general expectation is that countries will be keeping regular updates in their NDCs, and even if they're not, I think the earlier version will still hold, because the actual period of the NDC goes beyond the 5-year period for the most part. What we are expecting is that countries will be indicating who the designated authorities are, and the UNFCCC is also planning to compile all of the information on those authorities, which could be ministries, departments, sometimes committees in host countries. So the UNFCCC will compile a list of all those countries, so those countries' authorities, and I think this will also help greatly the process of being able to identify who to speak to and to be able to get the LOAs issued.
Great, thanks, Andrew. So there's another question about CORSIA labels. So regarding CORSIA Phase 1 label, which, to be clear, not available yet until ICAO provides full approval for that, but once available, there's some confusion as to whether an LOA is a requirement to receive the label or not. And then there's a reference to ACR. So Vera sets its own process, ACR and others set their own process. We generally try to align them, but there are going to inevitably be some differences. What we have decided for the VCS is the two labels can be requested independently if a project meets the criteria. So the Article 6 label can be requested once the letter of authorization is in place. The CORSIA Phase 1 label can be requested once Vera is approved under that program and if your project meets all the criteria. But both labels will be needed for retirement. So we haven't put conditionality on the labels, but there will be conditionality on the retirement that you need to have both labels in place. There's a question on CCB labels. So that's not the topic of today's webinar. We may not answer it fully, but I think there's maybe a little bit of confusion here between methodologies being eligible for labels. So when we talk about methodologies that are eligible for reduction or removal labels, the mitigation outcome type labels, that does not restrict whether a project using that methodology is eligible for any other label. So each label has its own criteria and requirements, which are available on the website. If you meet the criteria for that label, then you can request it. And a given project and VCU can have multiple labels as long as it meets the criteria for each. Okay, can it happen that a client doesn't want to divulge its retirement of an Article 6 VCU? Can the project proponent release its Article 6 label? That's a good question. And Ashley, do you want to speak to that? So we have required, partly because of the transparency needed for the accounting, that retirement reasons will be visible for Article 6. But do you want to speak to the specifics there, Ashley?
Sorry, I was just missing a question there. Can you just repeat the question? I'm trying to find it.
It's basically what happens if a client doesn't want to divulge the retirement of an Article 6 VCU. So basically, in general, people, in most cases, it's optional whether or not to list the retirement beneficiary and retirement reason publicly. But for Article 6, because of the need to do the corresponding adjustments and know the retirement reason, we are requiring that people publicly disclose that, right?
Correct. Yeah. So when you're retiring in the portal, you should be selecting make these retirement details public. And this is just for transparency reasons under Article 6. So I think that's relatively straightforward. Is there any other details you'd add to that, Andrew?
I'd just perhaps say that this is already a requirement for CORSIA. And that is a requirement which is set by CORSIA, that the information should be public. And generally speaking, I think it's good practice. It will be necessary for countries to understand what has been retired against its compliance reasons, including on our registry. So I think it is the way that this is heading, and again, this is something which is supported by ICVCM. So it's not only Vera thinking along these terms.
Okay, thank you. Sorry, Ashley,
I could give
did you want to say something
an
else?
answer. Yeah, so there's a question on please give examples of authorized uses. So there are the 3 authorized uses. The first is NDC use. So this is for use by the acquiring country for use towards their nationally determined contribution. So that one should be straightforward. It'd be a government using those VCUs. The second one would be international mitigation purposes. An example of this would be international aviation, compliance under CORSIA, or potentially forthcoming obligations under International Marine Organization. So there's some potential frameworks for marine shipping to also use under that framework. And then finally, other purposes would encompass a lot of different retirement pieces. So that would include the voluntary carbon market. Andrew, is there any other pieces that I'm missing there?
No, I think that's good.
Okay, there's a question. Can an Article 6 letter of authorization contribute to the demonstration of ownership for Indigenous project proponents? I'm not sure exactly what's meant by that, Andrew. I'm not sure if you know. Otherwise, we can ask that person to follow up by email. Okay. Leslie, this was your question, so please send us an email about it with a little bit more detail, and we'll get you an answer that way. Okay, we're getting very close to the end of time. Let me just see, there's what do you use if the host country will use it for its own NDC? So if a host country is not willing to make a corresponding adjustment, then they won't provide you a letter of authorization, so you won't be eligible for a label. Basically, the letter of authorization is that commitment to say, we're authorizing the transfer of this credit, we're committing to making the corresponding adjustment. So I think we'll leave it there. Nicole, I think you have a slide with the email addresses for people that want to follow up. Thank you very much, everyone, for your participation and your questions, and we'll talk again soon.
Yes, thank you, Justin, and thank you, everyone, both colleagues who were able to join and talk at today's webinar, as well as participants. Thank you for joining, learning more about VCU labels with us today, and for all of your really great questions. As I mentioned earlier, and as Justin just mentioned, you can email these teams for any follow-up questions that you have or any questions that we were not able to answer during the webinar. Program updates at vera.org is directly to our team, and we can answer questions more specifically related to, the program updates themselves that were just released. For general questions related to a specific project, info@vera.org is the best way to go. And then, as my colleague Kelly mentioned earlier in the webinar, registry@vera.org is the address to reach out to if you have questions specific to label applications for your project. Again, thank you very much, everyone, and I hope you have a great rest of your day, evening, afternoon, wherever you are. Thank you. Bye.
Thanks, everyone.